Today I am going to be illustrating to you with a real case that's currently in courts of law as to why the Fear Bill is an absolute time bomb waiting to explode in the faces of the British public and the most vulnerable people of society who lay at the hands of the prey of organisations like the Department of Work and Pensions when they have failed in their own duties and when judges themselves get things wrong. Now today the Court of Appeal have accepted my right to put before them the case that I took the Department of Work and Pensions to court over. Yes, it is true, I won various aspects of the 3 different cases, but one of the biggest aspects that I didn't win was in the dismissal, and I believe that I proved beyond all reasonable doubt that not only was the dismissal flawed in its actual evidence, so was the process of the tribunal. Now this is relevant because the Department of Work and Pensions are trying to put a costs order on me for a 6-figure sum when they were the ones that failed legally in implementing their own disability policies. So this is a video for every single person that has anything to do with the Department of Work and Pensions. Now, before the government gives itself even more power and more right to use the Fear Bill, I think it's even more important today for those same entities to be held legally accountable for their actions and also their failings, because it can result in people taking money from your bank when they've done something wrong or when there is an error. Now, in my particular case, there are various parts of my judgment where there are multiple inconsistencies and multiple errors that I proved in a court. However, the judge did not agree with me, and I'm going to give you one very clear example of how far this can go by using the publicly available judgment that the judge has written up at the Department of Work and Pensions request. Now, first of all, I'm not quite sure what version is actually publicly available because there have been 4 different versions of the judgment now that have been created, and it's taken me some time to go through the entire judgment. But if we skip through to page 94, which is, or paragraph 531 in particular, which is on page 94, I believe, we will come to something which is very pertinent in my case. Now, whilst I'm finding this, I am going to explain. I used to work, if some of you don't know, for the Department of Work and Pensions. I used to work as an enhanced self-employment work coach, so I used to specialise in dealing predominantly with that and dealing with quite complex cases of very unwell people, particularly with mental health and other sorts of conditions as well. Now, because of my pre-experience, so before I even started for the Department of Work and Pensions, I've worked always in the business and entrepreneurial space, and I now obviously work as a business coach now. I was actually asked to complete some work that involved scanning and looking at various claims of universal credit of self-employed people. And this was in connection with the fraud department, the fraud and compliance department. And let me just tell you, the reason why I'm telling you that and the reason why this is relevant is because whilst I was doing that project, I actually had to correct 2 team leaders on processes which they should have been applying. And part of my role with the fraud department at that time was to look at any processes or errors that were being made on claims and to leave my notes for other team leaders, other fraud and compliance officers to look at, so that they could make their decisions around that. So I was basically analysing for them. And that is relevant because those same managers that were involved in me finding fault with some of their work are the same managers that refuse to give me my disability trigger points as a disabled person. Now that's all I'm going to say on that for the moment, because the plot does thicken, and until other things are dealt with, I'm not going to go into the detail of that anymore. I'm going to leave it up to you guys to read between the lines of why that is so relevant. So let's go back to the judge's judgment. So just for example, there are over 1,000 paragraphs, and I have found many points of inconsistencies. There are many things that the judge has seen that were in the bundle, that were even emailed to her actually in the hearing. However, for some reason she seems to have forgotten to have seen those, or forgotten that they were emailed to her. So that is a matter for the appeals court to deal with. But I'm going to show you this one example. And whilst I do this, I also want to highlight here, please do not read or every single thing you see online, particularly in a judgment, and believe that it is, kosher, shall we say. Because when you see what I'm going to show you, you yourself are going to ask yourself, how the hell has this happened? Because this is exactly the situation that I'm in and many other people are going to be in. So let's have a little look at this. It clearly says, so I'm going to read it out. With the self-employment work coming to an end, Mr. Rogers, that is a manager, tells us, and we accept that there was a request for staff in the department to put their names forward for a fraud project. When they say we, the judge is meaning the court, okay? He thinks that the project might have been connected to self-employment work. As the claimant was working from home, her name was put forward to the site leadership team. That claimant would be myself. However, he says that she wasn't selected for the project and that in fact the project never came to fruition. That this was a project that has been referred to as the Frams project. It's just something, it's just a way we refer to it when you work there. Now I want you to read the next part. We accept his evidence about this. He observes that despite this fact that the claimant continued to insist that she was carrying out work for fraud and blocked time out of her diary for it. So here they are clearly stating basically that I said I was doing something that apparently I wasn't doing. So I was making it up, that it never actually happened. And these managers, by the way, I was working at home for 2 years. They were so on the ball about my tasks and my duties that apparently they knew every single thing I was doing. Well, really, that is really what should have happened, really. But because I was excluded from the moment I took legal action against them, now I'm going to show you the piece of evidence that was put before the judge in court in an evidence bundle and was also emailed to her at her request directly to her in the hearing. And this information, of course, she had prior to writing that judgment that you and I have just read. Well, first of all, I just want to draw your attention that this is an email addressed to me self-employment to me from the compliance functional team, so counter fraud and compliance, right? So clearly this is an email from that department. And because I didn't work for this department, this was the only time I did anything for them, we can safely assume that this one singular email that I have from them, there are another couple of other ones as well, but they're basically re-echoing this from other officers, basically. We can all safely agree that this is an email, does exist. Obviously, other information that I've blanked out here could and I should have been verified, I think, by the respondent and the judge herself, should she wish to, in my opinion, disprove that this, didn't exist, because clearly it exists. And let's read it. It says, "Hi Alison, I've had the emails below regarding the SCW GWI closed case test and was wondering if anyone had been in contact with you. Basically, I did the case check for compliance and was told, let me say that again. Basically, I did the case check for compliance and was told early on that the project would be sourcing a work coach." Now it's making sense, isn't it? The manager said that I was going to be doing it, but in actual fact, they took me off it when I made a complaint about a couple of managers. And they told me that this wasn't happening, that this whole thing that we can see here before us on this email wasn't happening anymore, and that it had actually been cancelled. Well, I'm pretty sure the fraud department don't just cancel things, right, like that. So I got in contact with them myself, and as you can see, they said, "I've spoken to a colleague who has now taken over the area of work as the lead, and in turn he's asked me to contact you to progress. Could we book in a call this week and I'll run things through with you and come up with steps for the cases. Hopefully this is okay, and could you let me know a day that would be convenient to book in the diary." In addition to this singular email, there are other emails from the head of the fraud department, which obviously are relevant to this, and a complete PowerPoint from that same department that I was provided with on the things that I was asked to do. That was also supplied to the court as evidence. And in addition to that, there are obviously screenshots of my own diary blocked out saying working on FRAMS or fraud project. So quite a lot of evidence, I think we can safely agree, coming from myself, the fraud department, my online booking diary, to clearly state what I was doing. However, even given all of that information, which is completely undoubtedly, evidence, because it's got all sorts of information on it, which obviously I cannot show you, to clearly back up what I'm saying. And I have a judge here saying that they do not believe me, and that they believe the other manager. We accept his evidence about this, and there are other instances in this judgment where the judge says the same thing, not just on this level, but on other points as well. This is obviously why this has gone to appeal and all the rest of it. If I'm not successful in the appeal, there is a potential 6-figure costs order, which I would find quite shocking that the Department of Work and Pensions would be successful in getting a costs order against a disabled litigant in person because they failed to put in their disability policies. And then we've got things like this in the judgment that don't really make sense because this evidence was in the bundle. And let's not forget that the court did have 2 entire days to read all of this evidence before we even went into the hearing. It's rather concerning if we were to take that type of information, those types of processes, potentially failures in processes, and then all of this attention to detail, accountability for, let's just say, tribunals, judges, people like the Department of Work and Pension, not really being made accountable very much for their errors. Yet when it comes to them raising costs orders, like as it would be potentially done with the fear bill, done at the speed of light. I think this is very, very concerning because it's making it very, very difficult. And by the way, this is now going on to a 4-year process for me to consistently have to deal with all of this as a litigant in person, no solicitor, no barrister, and respectfully, please stop mentioning the black belt barrister because I have been in that man's comments so many times. I think he just deletes my comments now. So I don't think he is somebody, he's a practicing barrister. I don't think he is somebody that would want to go up against such an organisation. So I am on my own, just like you would be on your own. And this is the big issue, I think, with the fear bill. It's given too much power to too many entities that make lots of mistakes. Let's not lie. This is why the Department of Work and Pensions itself has been investigated on the actions or inactions of failings where disabled people have been concerned, to the point of no return, I might add, for lots of disabled people. But it doesn't just end with them. It also ends with our own tribunal and justice systems as well, making clear and apparent I can't say at this point it's errors, that's for the EAT to say, but there are lots of issues with this judgment, lots and lots and lots and lots. And it assumes that there are no mistakes, and it assumes that frameworks are correct, that they have got all of these protocols to protect vulnerable people or protect even themselves when they make errors. And my case clearly illustrates that that is not the case at all. There is no protection for people like me, for people like you. And I'm quite lucky and quite fortunate that I've been able to get a grasp of legalities up until this point. But what about people that can't? What about people that don't have the same level of capability and skill set and experience that I have to be dealing with this level of legality when you're not a lawyer or you're not a barrister? I think it's unfair because the processes, when it comes to appeals, even when we look at the FEAR Act, the processes that are involved in appealing to these organisations is incredibly complicated and incredibly long, just like it is with a PIP appeal. You have to wait forever. And I just don't think that it's fair. I don't think it's lawful because lots of these processes come from error within the systems themselves. Right? So, because when we have a new act being passed about the accuracy of data, that is only relevant as much as it is of what's written on the paper. And as we've seen there, anything can be written on a piece of paper. It doesn't mean it's right. And that is my point. Let me know what you think in the comments.